Please be seated. We'll hear argument in 21-291, Texas Medicine Resources against Molina Healthcare, and 22-138, UnitedHealthcare versus ACS Primary Care, Physicians Southwest.
May it please the court. Mr. Trachtenberg will present argument for the petitioners. Petitioners have reserved 10 minutes for rebuttal.
Mr. Chief Justice, may it please the court. ER doctors save thousands of lives every day, and they have performed heroically and under great duress during the recent pandemic. This case is about whether these doctors can have their day in court and bring claims for fair reimbursement that they provide to the out-of-network patients, for the care they provide to out-of-network patients. 3 independent claims are at issue here today. The first claim is an implied private right of action claim, which is raised in both cases before the court, and it's based on the text of the Texas emergency care statutes. Those statutes say that an HMO or EPO shall pay non-network physicians and providers at the usual and customary rate for the out-of-network care. In applying this court's framework in Brown and Bullion, Judge Andrew Hainan correctly concluded that this language does imply a right to sue. The second claim is for quantum merit, and the only disputed issue here is whether the doctors provided a benefit to Molina and not just Molina's plan members. And as the restatement persuasively shows, they did because they performed Molina's core statutory obligation to provide health care for its members. The third claim is based in Chapter 541 of the Insurance Code. And the issue here is whether the doctors have the right to bring this claim either directly under the statute or as assignees of the HMO plan members.
Let me ask you something
Yes, Your Honor.
with regard to the statute. So the statute has a very detailed enforcement scheme which does not include this private right of action. So what is your answer to that?
You're talking about not talking about Chapter 541, you're talking about the emergency care statutes.
Right.
Well, there are a couple points I'd like to make to that, responses to that point, Your Honor. What the Dallas court pointed to was some very general statutes, and the insurers point to them here, that give the Commissioner of Insurance or the Texas Department of Insurance general authority to impose a variety of sanctions for any violation of any insurance code provision or regulation. But we don't believe that indicates any kind of legislative intent to deprive the doctors of a private remedy here. We know that the same TDI regulatory regime now exists alongside a arbitration litigation regime that the legislature implemented in 2019. And so we're now arbitrating and litigating these very same emergency care reimbursement disputes, notwithstanding the existence of this TDI regulatory regime. So if the legislature thought that the TDI was the hammer, so to borrow that phrase from Brown, then it makes no sense that they would have implemented this litigation and arbitration regime. I think it's another important point with respect to the TDI is that the insurance code doesn't create any kind of adjudicative mechanism within the TDI to resolve private monetary disputes between private parties, like you see in other areas of the law, like property tax disputes, workers' comp claims, utility rate disputes, and the like. There are literally millions of emergency care visits every year in Texas, and there's no structure, there's no empowerment of the TDI to adjudicate disputes arising from all those millions of claims. And in fact, since in the 20-plus years these statutes have been on the books, as far as we know, there hasn't been a single TDI administrative enforcement action arising under the emergency care statutes. I think I want to emphasize that this court's framework in Brown and Bullion is the right one, and it's completely aligned with the way the U.S. Supreme Court evaluates implied private rights of action as well. This court is focused on a fair reading of the text and not on any magic words and other formalisms. And that's the way the Supreme Court approached the issue in the Maine Community Health Options case in 2020. This court, in the U.S. Supreme Court, like this court, said the focus should be on the text of the statute to assess whether there's an intent to create a private remedy. And like this court, the U.S. Supreme Court rejected a magic words test that said there had to be explicit language calling for a private right of action, which would nullify the entire concept of an implied right of action. And as Oral Argument Exhibit 1 shows, the statute at issue in the Maine Community case, like the emergency care statutes here, had a shall pay command. And the 8-1 Supreme Court majority, citing Justice Scalia, held that where the statutory obligation to pay money is mandatory, then the congressionally conferred right to receive money will typically display an intent to provide a damages remedy for the defaulted amount. We are not asking the court.
How is that different, though, from Brown, where the statute said is liable for liquidated damages plus attorney's fees?
So in Brown, there was that language in the Brown to make the post-amendment statute. The court held that the post-amendment statute would create a private right of action, unlike the original statute. In large part because the original statute was a penalty statute that didn't confer any right of compensation to any particular party. But what was significant about Brown is its discussion of bullion and the takings jurisprudence from this court, where this court held that the takings clause creates a private right of action. It doesn't use any magic words. It doesn't have the words like, it doesn't have liable to or damages or attorney's fees in the takings clause. But the fact that it identified a right to compensation and a class entitled to that compensation in an amount conferred a private right of action under the Constitution. And the Brown court blessed that same analysis here.
But in here, could the provisions be read as establishing the appropriate payment standard when providers seek benefits via an assignment? Because here, there's this separate idea of the assignment of the insured's rights against the carrier.
Those are two different types of claims. The assignment claim, we would be stuck with whatever benefits are under the plan. The argument here is that the reimbursement level doesn't meet the statutory level. And usual and customary rate is not just what the insurers say it is, despite their kind of late argument on that point.
Right. But could be read sort of as informing whatever action you have under your assignment rights, as opposed to creating an independent private right of action?
I think I don't see how that can be reconciled, because I think in your assignment rights, you're stuck with whatever rates are in the insurer's plan. And here, the legislature, as part of to protect the ER doctors who are engaged in a compelled transaction here, they have to treat all comers. They have to treat out-of-network patients. So part of the protection here was to make sure they get a usual and customary rate, which you see now translated into in the new statute. There's a 1467.083. I'm sorry, let me take a step back. Senate Bill 1264, and the bill review that talks about the purpose of the statutory purpose of the amendments. It's to make sure that ER doctors are getting paid reasonable value for their services. So we think there's a discrepancy between an ERISA type of claim and a usual and customary rate claim under the statute.
Is there disagreement about how these disputes are resolved after 2019?
There's no dispute about that, Your Honor. So all these claims that we're bringing now are pre-2020 claims, and they would all, Chapter 541, quantum merit, private right of action, they would all be now pushed into this arbitration litigation regime, and that's where these disputes are taking place post-2020.
So how do you enforce an arbitration award under the new regime?
Well, the statute provides for a right to judicial review under a substantial evidence standard if you...
Right, but is that different from enforcement? Like, I don't disagree, but I'm not going to pay? What happens then?
I think there's a statute that the 1467 gives commands about when the payment should be made. I don't think the enforcement is a problem from my understanding of how the regime is working.
So this case is of limited significance.
It is of limited significance in terms of both the time period and in terms of if this court is concerned about creating willy-nilly, implied rights of action willy-nilly. I think it's important to point out that that's not the case. Well, we're talking about situations where the legislature does three things. It identifies a payment command, it identifies a class of people entitled to payment, and it identifies the amount of compensation required. And the legislature doesn't do that all that often. So we're not talking about opening Pandora's box here.
What supplies the Tucker Act analog here, that the Maine Community Health case, or Justice Scalia's dissent in that 1988 case, which I'm forgetting? There you had an existing federal statute that describes what to do when Congress talks about an obligation of the government to pay something. So what is the analog here to that would?
The way Maine community describes the Tucker Act situation is all it is just a waiver of sovereign immunity. It's basically turning the government into a regular litigant. It doesn't, the court is clear in Maine community that that doesn't confer any kind of independent right to a remedy. It's just a waiver of immunity. You have to look to a separate statute to find an implied right of action, and that's what they did in Maine community. They found the ACA statute that had a shall pay command, also a specific set of entitlement of people that were entitled to receive payment under that, and a statutory formula to determine the amount of payment. So that's the parallel there.
So, counsel, in the absence of the statute that requires the usual and customary rate, or maybe before it was enacted, was there an obligation to pay these doctors under these circumstances? And if so, where did that come from?
I don't know the history of the federal act how long that's been in place. Perhaps I can find the answer. There's a federal act that compels care, and I don't know the answer as far as this. But
My question is,
yeah.
Is the obligation that the plans have to pay the doctors, does it arise entirely from this statute? Or were they paying some rate in the past, in the absence of the statute, in recognition of some obligation of some sort, and then the statute came along and sort of fixed the rate at which that obligation had to be discharged?
You're right. I don't know the history. I'll try to find the answer for you and before my rebuttal argument and see if I can get a better answer for you.
Well, doesn't the obligation, at least in some part, arise from the assignment of benefits? So in other words, the insured has some benefits with these plans, which by receiving care, usually the person signs off.
Right.
And so there is that obligation for the plan to pay, but you're saying it's inadequate because the amount paid by the plan is inadequate.
It could have been that the answer was that the economics were different, and there was this problem about inadequate payment arose in the context of other developments in the healthcare industry. I just don't know the answer.
Elimination of balance billing.
Well, that's a part of the answer here. Well, they do go hand in hand, because when you have no remedies, as the insurers do, when you can't balance bill, and you don't have any judicial remedies available, at least not yet, the insurers can basically dictate whatever the payment is, and the ER doctors have been stuck with inadequate reimbursement for a long time now.
What about this issue of, charge master rates? And let's say if that's what's being sent and the insurance company or the HMO is deciding that that's just hugely not reasonable and not customary, what would happen in that situation, and how do you determine what's reasonable and customary? And how does that fit into this?
Well, the reasonable customary, usual and customary implies some kind of, let's make it clear, we are not seeking charge master rates throughout our pleadings.
I understand that, but let's say in a situation where maybe they were,
No, I understand. I think that's what usual and customary is designed to get at. The
Right.
legislature didn't flesh out the meaning initially as far as what usual and customary meant under the original statute. But if you look at 1467-083, now that we're in the arbitration litigation regime I'm talking about, they've now listed a number, like 10 factors that go into that determination. So bottom line is usual and customary implies some review of the overall market. It accounts for market and geographic differences. It's not just whatever whatever the providers are picking a number. That's not the case here. I do want to make sure I get to the quantum merit and Chapter 541 arguments. I want to make sure I answer all the questions about the private right of action claim.
I have one last one, and that's just to make sure. I think what you said was that everything that you understand to come from Texas law on implying a private right of action is consistent with the Supreme Court's law. So you don't think there's any current binding Supreme Court precedent that we would wrongly follow, or that Texas deviates in any way?
I think Maine Community Options, which is the most recent private right of action damages claim, lines up very well with Brown and Boolean. I perceive no significant differences between the court's approach there and how this court analyzed the issues in the Brown and Boolean case.
Under the 2019 amendments, you agree you would not have a private right of action?
Under the 2019 amendments, we have the right just to go arbitrate.
Right, but not to go sue directly.
Right, that's right.
But to seek to enforce the arbitration award later.
Right,
Right,
those right.
you can sue to enforce the administrative award, but you can't sue directly under a statutory or contract claim.
I want to make one clarification. It's not just sue to enforce, but if you disagree with the arbitration decision, you have the right to go challenge the arbitration's decision under.
Do your clients have the option of pursuing that process with the charges at issue here, the pre-2019 charges?
We do not.
Okay.
So turning to the quantum merit claim, the dismissal here was based on, against Molina, this was just on the Molina issue. But this was just based on a single argument. The doctor's services benefited only the insured and not Molina.
Could you help me understand the benefit, the issue on the quantum merit, by explaining, the HMO has this duty. What conduct would the HMO engage in to discharge the duty that it is not having to do because the ER doctors have done it in its stead?
They have to secure a network of care. They have to make sure they have doctors that can provide all the necessary services to their members. They have the fundamental obligation ultimately to make sure that their members receive the health care that they're entitled to. It's inherent in the very title of health maintenance organizations. And the statutory code 843.002 makes a point to distinguish in the definition of HMOs between provision arrangement of healthcare services and simply indemnifying for healthcare costs. And so, in this case, if you look at an oral argument, Exhibit 2, Judge Cardone of the Western District identified this precise issue as the key determinant for why there should be a quantum merit claim under Texas law under this benefit analysis. And this court hasn't reached this issue, and actually no Texas intermediate court until the Dallas court has either. But I think the restatement, third on unjust enrichment, really provides a lot of persuasive guidance on this question. Section 20 of the and then we have a key example in the restatement that's set out in oral argument Exhibit 2 as well. But Section 20 of the third restatement teaches that the claim for emergency medical services is one of restitution's paradigms in the absence of a contract. And Section 22 anticipates this precise situation, and it provides that a person who performs another's duty to a third person and is entitled to restitution from the other as necessary to prevent unjust enrichment if the circumstances dictate or justify the decision to intervene without request, such as when a third person faces imminent harm. And again,
is that inconsistent with our decision in Truly, where we said it's not enough to merely show that the plaintiff's efforts benefited the defendant, but the plaintiff must show that his efforts were undertaken for the person sought to be charged?
I don't think so, Your Honor. Truly is kind of a unique situation. It was a joint venture, and the plaintiff there was one of the three members of the joint venture. He claimed to deserve compensation for the services he provided towards that joint venture, but he actually blew up the joint venture by failing to comply with his own obligation. And in the case, he was trying to seek a remedy from his two co-venturers, not the co-venturer itself, and trying to get quantum merit relief. And that was the context in which the court made its comments about benefit. But I don't believe the court has squarely addressed the benefit question as it's presented here. And would urge the court to look at some of the examples we provided from the restatement and out-of-state jurisprudence that provide, I think, very helpful guidance. We believe this is a paradigmatic quantum merit case. In my remaining time, I want to just talk about Chapter 541 very quickly. As to direct standing, we have direct standing under this to bring these claims under 541-151, because that statute says a person who sustains actual damages as a result of an insurer's unfair or deceptive act may bring an action for any damage sustained from that act. The other side has made the argument that we should read into that phrase only an insured or beneficiary can bring that claim. That was expressly rejected by this court in Crown versus Castile back in 2000. In the 22 years since that case has been on the books, the legislature has had every opportunity to insert those words into the plain statutory text if it thought that claim should be limited to an insured or beneficiary. It hasn't done so. We think that's a plain reading of the statute to give us direct standing under that claim. We also believe.
But it's not really standing, right?
It's not really, I use it's the class of people within, that have the right to bring the claim within the statute. Fair point about that.
And to be clear on that point, on 541, even if we were to hold that you have no private right of action and no quantum merit claim, issue 2, your position would be, well, even still, we could sue for these damages under 541, statutory damages under 541.
Yes, but even if you think that there's no implied right of action under the emergency care statutes, they still, I think we all agree, create a mandate or create a requirement that the insurers are supposed to follow, whether it's from the TDI enforcement or whether it's enforceable by private right of action. So to the extent they have an obligation to pay at the usual and customary rate, and they don't offer settlements, equitable settlements that are approaching, even anywhere approaching that amount, we believe that qualifies, that triggers 541 liability under.
But under that theory, in that suit, you would not be allowed to recover your actual damages. You would have to prove you sustained actual damages, but they would not be recoverable because you have no private right of action or quantum merit claim. You only get statutory damages.
We get statutory,
What would be the basis for recovering the actual damages? The authority for recovering under 541?
I think would be the gap between the settlement, the gap between what was offered in the settlement and what we were entitled to under usual and customary rate. I'm just, right. I see I'm well past my time, but thank you, Your Honor.
Any other questions? Thank you, Mr. Trachtenberg. We'll hear from the insurers.
May it please the court. Mr. Collalori and Mr. Gunn will present argument for the respondents. Mr. Collalori will open with the first 15 minutes.
May it please the court. In Brown, this court said that the test for implying a private right of action under a statute where the legislature has not specified one is a strict one. We will strictly construe. It must express in the words of the statute, not just that there is a right to some form of compensation or some other wrong that is being addressed, but that there is also a judicial remedy. Has to be expressed in the statute.
What if the HMO paid nothing?
What if the HMO paid nothing to the providers? Mm-hmm. The HMO is not obligated to pay anything to the providers. The HMO reimburses its insured for.
Well, but that's what I mean. Yeah. What if the payment that's supposed to be made, the usual and customary, was zero?
Well, then the insured will certainly have a claim under their policy against the HMO for failure to pay in accordance with the provisions. The provisions regarding what an HMO contract has to provide for, including usual and customary rates, are incorporated into the policies that then get sold in Texas. And the insured has a right to bring a breach of contract suit.
Why would they ever do that, though, if they can't be balance billed?
Well, they could be balance billed until SB 1264 was enacted in 2019. And I want to come to that. That is an important point here, is that historically an out-of-network provider looks to the patient. And that is why you have under preferred provider plans, HMOs, you have a network. When somebody's out of network, there's no relationship for the insurer to pay that provider.
So you would say in the absence of the statute, there's no obligation at all to pay the provider or to make any payment, or it's just purely a matter of the relationship between the HMO and the.
It's a matter of contract.
The insured.
That's correct, Your Honor.
Is there any obligation that flows to the provider from the HMO in the absence of the statute?
Not before 1269. Before 2019, before Senate Bill 1264, there was no right of payment directly to the provider. The plaintiffs continue to assert there was, but if the court looks at the HMO statute and the PPO statute, it says that the HMO shall pay at the usual and customary rate for emergency services provided. The PPO statute, during the relevant time period, says reimburse at the preferred level of benefits. And just recently,
Or at the usual customary rate, or at an agreed rate and at the preferred level of benefits?
that's post
That's not for
1264.
2019?
Before 2020, the statute said only at the preferred level of benefits.
What about the EPO, 1301053A?
Well, it somewhat confusingly says you shall reimburse
The
the provider, which we think is a little bit inconsistent. Reimburse means repay, refund to someone, suggestive of the fact that it is the insured's obligation pre-1264. So what the usual and customary rate language was intended to do, and this is discussed at some length in the amicus brief, was to make sure that in certain instances, if you go out of network, either because you don't have a reason to know that when there's undisclosed providers at a in-network facility, or, relevant here, when it's an emergency care situation. You don't necessarily get a choice. And the statutes are designed to recognize that and to say, you're going to get paid at the usual and customary rate that this plan pays for in-network. That's what the usual and customary rate meant when it was enacted. That's what the amicus brief deals with at some length. The Fort Worth Court of Appeals, just very recently, in the last few weeks, in a case called Aetna versus Nazarian, which is an appeal from one of these arbitrations, the site is 2022 Westlaw 3273596, said the purpose of the usual and customary language was to not penalize the insured for having to go out of network on certain types of care, not to compensate the providers directly.
But if the providers are asserting a claim against the insurance company via an assignment of benefits and stepping into the shoes of the insured, then don't the providers have the obligation to reimburse, the insurance companies have the obligation to reimburse the providers at the usual and customary rate? I'm getting the impression that that's not what's happening.
Well, actually, that is what is happening. This was a motion to dismiss in federal court. We don't have a record of facts, but the
amicus says the insurance company determines that rate and it's not challengeable. And I'm just wondering, is it challengeable or not?
It is not, it's not.
When it's done via an assignment of benefits, of the insured's benefits.
It would be the same issue as the insured, if he had not made the assignment of benefits, could challenge, you're not really paying the usual customary rate as specified in your policy. The doctor stepping into the shoes of the insured could do the same, but these providers did not want to assert a contract claim or an ERISA benefits claim under the policies. They made that abundantly clear, affirmatively said, that's not what we're saying. We want this different claim. And the source they went to was this emergency care statute, which is intended to equalize the out of network with the in-network to make sure that the insured is not getting penalized for going out of network. And if we think that was clear, or certainly the more logical reading of the statutes before Senate Bill 1264, what's ironic now is Senate Bill 1264 has actually added a definition for usual and customary rate. Now, it's in the sections for government employee health plans, and those sections got added. They were not there before, but they now mirror what the post-1264 PPO, EPO, and HMO statutes say. And the legislature has now defined usual and customary rate as the level of benefits provided by the health plan.
So it's your position, if I required emergency care, physician charges me 10 grand, and your client says, no, we only pay 3 grand for that service, and physician says, well then Boyd, you owe us 7 grand. It's your position, I could sue your client for breach of contract, for not paying an adequate rate for the services that I was required to receive?
Well, we certainly don't think that is a legitimate claim to say, well, the bill went out at the charge master rate of
You would
$10,000.
argue there's no breach there, but you don't dispute that I would have standing, authority, injury, or what, a jurisdictional basis to file the suit.
Obviously, insureds, they've got a contract, they've got the ability to.
And so in the same way, you agree that I could assign that right to the physician and let the physician sue you for the $7,000 difference under that same contract theory?
If they're suing under the contract of the plan, I don't disagree.
But the contract doesn't guarantee a customary and usual payment, is that?
Well, the statute says usual and customary, which has been interpreted to mean equivalent to what you're paying in network. Don't penalize somebody for going out of network. And the balanced billing problem was the driver for Senate Bill 1264. It is titled a act to protect the insureds primarily from balanced billing, and it stopped it. And what it did do when it stopped balanced billing, it said no more balanced billing for these sort of services, is it enacted a whole new regime that says several things. Number one, it says now.
Before we get to
Sure.
the new regime, let me finish my thought here if I can. So if I, as the insured, have the right to sue you under the contract, I may be wrong on the merits, but you agree I can sue you on
Sure.
the contract. I don't need these statutes to give me that right because we've got the contract.
That's exactly right.
And your point is the provider doesn't have the contract right unless I assign it to them and they sue on that basis, right? So then what do we do with the language? All three statutes says that you must pay the usual and customary rate or an agreed rate. What is agreed rate? Does that mean agreed between you and me, the insured and the insurer? Or does that mean the agreed rate between the out-of-network physician and the insurer?
I think that would most likely be referring to an agreed rate reached with the provider.
Okay, then if that's the case, do you concede that the statutes grant a private right of action for an out-of-network provider to file suit to enforce an agreed rate?
Well,
Or would your argument be they don't need the statute because the agreement creates a contract claim?
that would be my
But if
argument.
that's the case, then why do we need that language in these statutes?
Because the premise is that this is what you will pay, the usual and customary rate. Here's your network level of benefits. However, a provider could take up directly with the insurer, if I'm going to treat them, we want to have this rate of payment.
Right, but if that happens, they have a contract claim, you say, and so there's no
Absolutely.
need for that or agreed rate language in the statutes. They don't need a statutory basis to sue.
Well, and I don't think that would give them a statutory basis. Referring to the idea that there might be an agreed rate apart from the usual and customary rate set forth doesn't mean that that action is now under the statute. It's still under the contract that you made with them. Our point is these are contractual disputes between the insured and the insurer, potentially. The providers very often, probably almost all the time, there is an assignment of benefits for them to step into those shoes, but these providers don't want to do that. And so they want to instead look to the statute and say, you should imply a private right of action under there where there is none. But to go back to, well, what did 1264 do? 1264.
Let me ask you about that, because there's an arbitration process now, and it says if you don't like the rate, you can challenge that in court. But how do you enforce an arbitration award under the revisions to Chapter 1467? If you say there's an award and then the insurance company doesn't pay within 30 days as required under 1467-089D, does 1467-085A provide an implied private right of action to enforce the arbitration award?
Your Honor, I'll confess that's not a question I haven't thought about. As counsel noted, we don't have any claims in our case under the new regime. If there is, one would assume that if there was a dispute as to the arbitrator's findings, someone will avail themselves of judicial review.
Okay, but in my hypothetical, there's no dispute. I'm not challenging the amount. I don't feel like paying it, and I'm not going to pay it. Is TDI the only person that can make you pay it, or does saying in 085A, an out-of-network provider or health benefit plan issuer or administrator may not file suit until the conclusion of arbitration? Does that imply that you can file suit to collect the award after the conclusion of arbitration?
My argument would be yes, Your Honor, although, again, I have no knowledge of that ever occurring and have not really studied that issue not being part of our case.
Judge Hainan thought that addition informed the meaning of the earlier enacted text. In other words, you can't file suit until indicated that you used to be able to file suit sooner. What's your response to his view of that?
Well, as we argued in our brief and to Judge Hainan, that in fact there are available suits, the most likely one being exactly what you pointed to earlier, Justice Bland, which is a breach of contract suit as the assignee. So there are all other manner of suits that could be brought. There are promissory estoppel claims that are brought by providers from time to time. There are various types of representation-based claims that are brought. All that the statute now says is that to the extent there is any remedy that someone may be seeking outside of this process, it has to wait until the process is complete, the arbitration is complete. So that's there's no way that says anything about, well, the emergency care statutes provided you with an implied right of action all along.
Any other questions? Thank you, Mr. Colloy.
Thank you.
We'll hear from Mr. Guy.
Good morning, and may it please the court. I'd like to walk through the three issues. We overlap on the first issue about 1271 and the private cause of action. And we start from the proposition it's an issue of separation of powers and statutory interpretation. So we look to your precedent. Brown is the leading case, and that's where we begin. I won't give you a result of a word search for strict construction rule, which we've had a bit of a semantic clash about. I'll tell you, it's cropped up repeatedly in 18 years. The lower courts have had no trouble understanding what you meant when you said you favor that rule of strict construction. So that has cleaned up a lot of problems, and you now see the legislature constructively writing in the statutes to clarify all doubt in advance. Is there a private cause of action or is there not? That happens all the time. So that's a positive development, and I hope we don't backslide on that. Now, you heard the argument, and you've seen it in the briefing, that we're asking for a magic words test. And I have to say, that is a surprising argument. If you will listen to the oral argument recording from the Dallas Court of Appeals, it was the other side who was pressing magic words. Go to 14 minutes on the recording and listen, and you will hear one of our friends arguing, here's the magic language. There's magic language in Bouillon. There's magic language in Maine community. I don't think it's about magic language. It's just, give me a clear statement. That test has been workable since Brown. So let me start with what the Dallas court did and why it is correct. The Dallas Court of Appeals said two things. We see silence about a private right of action, and we see a detailed administrative enforcement scheme. Put those together and you have a very strong case. Some courts call it a presumption. That's all they did, and that was utterly orthodox. What about Maine community, which has sort of popped up in this debate? Maine community did not involve an implied private right of action. Search the briefing. You won't find any of the cases, Court versus Ash and Cannon and so on. That was not what the parties were fighting about. It was a Tucker Act case from Tucker Act world. And the majority actually starts by saying, here are the three questions before us. It's not an analog to what we have here. Tucker Act world is a separate regime involving the government and sovereign immunity. The main community case involved anti-deficiency. It's sort of the idea that appropriations process in Congress has certain requirements before money gets spent. So it's just a different dynamic. But there is an analog in the Tucker Act jurisprudence. If you have a detailed remedial scheme, then the courts will step back and say, we're not so crazy about allowing a money damage claim against the government. I refer you to Roman 4b of the Supreme Court's opinion there. They looked, is there a separate remedial scheme? Is there an avenue for relief under the APA? They found neither. That is a huge distinction here. You could accept everything you've heard about Maine community, and we would still win because we have the detailed enforcement scheme. I wanted to bring all the volumes of the insurance code to court today, but I'm not strong enough. There's too many of them. It is about as detailed as you could get. So we tried to collect highlights of the commissioner's enforcement powers and give those to you. Those are huge enforcement powers. So I don't think there's anything in Maine community that is a problem for us. Second, the Bullion case, which TMR told the Dallas court has magic language. Again, I don't think Bullion is particularly surprising. Without adequate compensation is the phrase that TMR told the Dallas court was determinative. But Bullion is taking a property, it has internal limits, and it limits that concept to its context from the Steele case. So we don't need sort of the equivalent of a Bivens action for out-of-network doctors. What about the 2019 amendments? As you know, Judge Hanen looked at those, and all I can say is I like half of Judge Hanen's opinion. I like the half about quantum Merowit. This part I don't like so much. I do not understand looking to a later legislature. He actually says that the new language, quote, indicates that the Texas legislature interprets the emergency care statutes to create a private cause of action. Legislators don't have a robe and a gavel. There's one department of government that interprets, and it's this one. It's not the legislature. That's old teachings from the Rowan case in the 50s. We know the difference. Second, the 2019 amendments are somewhat helpful. I'm not an expert on them. I've become an expert on old law after it's been in effect for years. It takes a while to get to my desk. But the 2019 amendments add the word directly, pay directly, and it identifies the providers. That was not there in the old scheme. The legislature has asked for periodic reporting under Senate Bill 1264 for the TDI to make regular reports. How is this working? Is it fixing the balanced billing problem? What is happening? You have an example attached to the friend of the court brief. They have a big toolbox. And so if somebody just says, Your Honor, like your hypothetical, I don't want to pay it, I assure you there are people watching, and there are people with a lot of tools to deal with that. I don't think that's a risk. There may well be just a right to enforce it and go get a writ, but I don't think it's ever going to come to that. I can't imagine an insurance company saying, I'm just not going to do it, sort of the Bartleby, the Scrivener's view. The TDI will come down on them like a ton of bricks. And I won't go through all of the powers, but number 13 in my laundry list of several dozen statutes says that the commissioner can tell the insurer to make complete restitution for someone who is harmed by a violation of or failure to comply with this code.
Is there a
So
record of that happening before this case? The TDI taking enforcement actions against insurers on the ground that they did not pay usual and customary rates to non-network providers?
I don't know of a record on that. You can go to the website and see all of the speeding tickets or whatever citations you want to call, and it just goes on and on. I didn't stop to read through all of them. We're here on the pleadings, but I find it pretty unpersuasive when they say, oh, it doesn't happen, it can't happen, when I've given you 30-something examples of statutes showing their powers. It may be that everyone's complying and that's not a problem. But when there were economic changes in the healthcare industry and somebody made a decision in a tall building, I think we can make more money litigating for profit, then you got these claims, and we're here on basically 2017 to 2019 claims.
Well, you say everyone's complying, but what history we have so far of arbitration decisions tend to award more than what the carriers paid to the physicians, at least so far.
It looks closer. Looks to me like it's a little bit more, but nothing like what was asked. It's a baseball arbitration scheme, right? So the arbitrator has to pick one of the two, but I don't claim to any expertise on what's happening so far.
What do you make of the or an agreed rate language in the 3 statutes?
I wondered about that. I'm not sure. I mean, I had just thought that meant if you're in the network, then that's what you pay. I had not thought of.
But the statutes address the obligations to non-network, for non-network services. So it'd be weird to construe them to have this little clause that covers network providers. And
Agreed.
so it seems that it has to deal with either an agreement between a non-network provider and the insurer. Look, if I ever cover your people, you're going to pay this rate. Or maybe a policy could say, well, here's what we'll pay for non-network care, right? Then it'd be an agreed rate.
Yeah, I don't know, Your Honor, and I don't have a better answer than my friend gave you. If I could touch on quantum Merowit fairly quickly, because it's issue 2, the claim is unsuccessful for 3 reasons. It is repackaged under the statute. Number 2, there is no benefit for the defendant, just on the elements of quantum Merowit. And then number 3, Judge Hainan explained, this is foreclosed by the express contract rule. Now that may be just another way of saying it's a repackaging problem. We're used to saying, hey, you have a contract, so you don't get an implied contract claim. You have an express one. This is a little bit like that. Hey, you have a statute. You don't need a gap filler. These equitable theories can get amorphous and sort of take over the garden if they're not reined in. And so I would say, be cautious with allowing this. I think the repackaging rationale that the Dallas Court of Appeals went with is pretty persuasive. But let's just take quantum Merowit on its own terms. The idea that there's a benefit for the defendant is really not persuasive at all. That it is not for us. It is for the patients. We don't know it's happening at the time. We're not given notice. What's the 4th element? We're reasonably notified. We don't knowingly accept. This all happens before we even hear about it. So quantum Merowit is problematic on multiple levels. They just can't meet the elements. They don't have a valid quantum Merowit claim. In the interest of time, I'm going to move through that and go to the 541 issue. And I think there's been a little bit of a communication failure between the parties and the courts as it's come along, because some of the 541 argument was sort of a tail on the dog that didn't really get much attention. I'm not saying briefing waiver, I'm just saying that's why it's not really developed in the Court of Appeals opinion. The main arguments below were based on assignment and 541 claims by assignment. The idea of direct standing was barely in the papers below. And I'm going to say it's there, but it got no attention, and so the Dallas court didn't spend much time on it. Dallas court held 2 things. First, the physicians are not insureds or beneficiaries to which the unfair settlement practices statute applies. Second, they cannot take by assignment from the insureds. That is, claims under Chapter 541 of the Texas Insurance Code may not be assigned. So let me start with direct standing. The Court of Appeals said the plaintiffs are not insureds or beneficiaries to which the unfair settlement practices statute applied. It was not a developed discussion of the point. I think what they are saying is you don't meet both requirements from Castile, personhood and a violation of one of these listed acts. So there's 2 pieces to it. The personhood piece is kind of how the briefing has gone. That's not particularly difficult or controversial. We are all persons. The question is what kind of person can bring the claim. And I acknowledged In the 20 years since Castile's discussion, which is headed as a standing discussion, we've refined the understanding of standing after Pike and so on. No quarrel about that, but we're here. So if you look at the beginning and the end of Roman II of Castile, you will see twice the court has this dual requirement: personhood and a violation, a who and a what. And what we've heard so far from the other side is just, I'm a who, I'm a person, therefore I can pursue this claim. I don't think that's accurate at all. The Dallas court thought the what, which was missing, was under 541.060A with respect to a claim by an insured or a beneficiary. I think the petitioners are saying, oh, we have that. If they have that, they certainly do not have B. They certainly do not have they can't get over B, which codified your Allstate Watson decision. Their claim is based on the liability of the insureds, and it is not actionable under 541.060. That's Castile in footnote 1, square on. So if you just read the front and back of section 2 of the Castile opinion, you'll see what I'm saying. Finally, assignments, which is, it's a PPG problem all over again. I mean, PPG, you had these big, huge companies, and the court said these claims are not assignable. Here, we've been sued for penalties, and the allegations are that our insureds came to them in obstetric distress, with cardiac arrest, with burns and broken bones and so on, and then somebody in accounting says, here, sign this assignment right here. I mean, the overreaching there is far beyond the overreaching in sale of a skyscraper, like in the PPG case. All of your policy reasons in PPG apply here much more strongly. Consumers are likely to be at a severe negotiating disadvantage. It is one thing to place the power of treble damages in the hands of aggrieved parties of the Attorney General. It's quite another to place it in the hands of those considering litigation for commercial profit. PPG is square on. You're not going to hear much pushback about that today. I think they know it is a barrier. These claims are much less assignable than the claims were in PPG. Chief Justice, the remaining 6 seconds are yours.
Any other questions? Thank you, Mr. Gunn. Mr. Trachtenberg, you have 10 minutes.
May it please the court, and I'll try to be quick. I know I'm the last person standing between everybody and lunch. I wanted to start with the Chapter 541 point that my friend just referred to. On the direct standing issues, he argues it was barely in the papers. That wasn't our issue. We fully briefed the question of whether direct standing applied under the statute and under Castile. If it wasn't fully vetted, it was because their only argument in response was that we didn't, even though we made the statutory argument in the Court of Appeals, we didn't say the magic word Castile in the Court of Appeals. But it's fully briefed for this court's resolution, and it's a plain language argument. And again, this court only departs from the plain language if it would result in an absurd result, which is not the case here. Again, that Castile's been on the books for 20 years, and the legislature has not addressed that. I want to answer Justice Blacklock's question from earlier, which is that prior to the emergency care statutes, there would have been a quantum merit remedy. That would have been a freestanding remedy, and that also kind of disproves the point about why the repackaging argument doesn't make sense. If we had a pre-existing quantum law remedy under just basic, if we meet all 4 elements of quantum merit law, it makes no sense why the legislature's passage of emergency care statutes that were attempted to help emergency care doctors, and at best could be argued were silent as to whether there's a private right of action, how that could somehow abrogate pre-existing common law rights makes no sense to me. This court requires clear abrogation language if it's going to, if that argument were to work.
What's the problem with approaching this as a contractual claim that's in the hands of the insured that can be assigned to the doctor?
This is because we have a right independent of the claims, the contractual claims for the patients, because those are restricted to whatever the contract says between the insurer and the insured about what they're going to pay for out-of-network care. And what the emergency care statutes do is provide a separate independent right for us to be compensation at the usual and customary rate. And it also.
But you said you had a quantum merit claim before, in
Right.
the absence of the statute.
We do.
And
It's
in the absence of the statutory right to direct payment, why wouldn't we look at this as a matter of contract between the insured and the insurer, and the doctor can be assigned that claim, but that would sort of swallow up any equitable remedy like quantum merit?
Because if it doesn't cover a reasonable value of our services, and that's what we're claiming we're entitled to.
So your position is that there's no ability with seeking the insured's contract remedies to push back on a carrier that doesn't pay the appropriate rate?
My understanding is if we get an assignment of benefits, we're stuck with the plan. We don't have the right to.
Well, surely the insured can challenge it, right? If it's.
The insurers kind of take it out of the equation now. They don't have any incentive to challenge it. They've assigned the benefits.
Right, no, but before that, the insured had the incentive and could. So now the provider has the incentive. And what's different about the provider asserting that right? That, hey, this isn't usual and customary. I just don't know.
They don't. I don't think the insureds were held harmless too before 2019 under an administrative rule.
In any event,
Right.
The party that is financially impacted by it, why don't they have an ability to challenge the determination that's made?
There's been no legal framework allowing that. This is the avenues that we've pursued is under the statute or under quantum merit or under Chapter 541. I want to go back to you asked the question about the 2019 amendments, and the answer was, why not just bring a claim under the statute? I think that goes to the same question, because the Section 1467.083 talks about the reasonable value of the services and how you make that calculation, and it lists a lot of factors that go well beyond what they're talking, the types of factors that they're considering, suggesting consideration of. On the one last couple points I want to return to on. First, on the idea that this pervasive regulatory regime swallows up our implied right of action. If it were the case that the legislature passed a bill, sorry, I got the wrong paper here. If the legislature were passed a statute that said oil and gas operators shall pay a landowner for the cost of remediating an oil spill on his land, would that not create a private right of action, even though there's clearly Railroad Commission authority and TCEQ authority to regulate oil spills? I think it's a hypothetical example, but the point is when you have a clear statutory command to pay money like you do in this case and in Maine Community Health, we believe that creates a private right of action under this court's Brown and Bullion framework.
You only think that that's true if it's about paying money. If it was, the oil company must provide timely notice to the landowner of X, Y, and Z, and they don't. That's a clear legislative command. It's a clear right to receive notice. But you would say that that is not something that would create a right of action?
Well, there can be right of actions for equitable right of actions where you can go to court not seeking a damages remedy, but seeking enforcement of a statute. So
but if it were something and you could say, I've been damaged by this, if I had only had that notice, I would have had this much money, would, under that hypothetical, there be a right of action for damages? Clear legislative command, you must get this notice. Clear case for how I've been harmed and how my bottom line has been undermined by not getting it.
I don't think that creates a damages remedy under that hypothetical, because you're not creating that textual entitlement to compensation.
So that's what it is. It's got to be a textual entitlement to money and not just a right itself that's been violated that caused you financial harm.
Exactly. Okay. And I want to address the kind of the late argument that usual and customary rate under the statute means whatever the insurer's rates. That's not an argument that has been made by any insurer in any of these cases until I think United's reply brief referenced an amicus brief that had made that argument. And in fact, I think it's fairly outside the scope of the appeal according to United's own argument. And their opening brief, page 25, footnote 9, they said, usual and customary rate means, or how it should be determined is not before the Fifth Circuit on this interlocutory appeal, nor encompassed by the question certified by the court. But I think it's wrong anyway, and we'd be happy to, if the court is interested in that issue, we'd be happy to elaborate on it. We just haven't had a chance to. It came in after our briefing concluded. But there can't be two different statutory commands. Under 14, under the emergency care statutes, they have to pay the usual and customary rate, and under this arbitration regime, we arbitrate and litigate whether they paid reasonable value under all these factors. They can't, their payment obligation can't be different under those two. And I think it's also a plain language analysis of the 1467 of the usual and customary rate too. I think inherently references a broader, what else is happening in the industry, what else is happening in the market, and also I think to Justice Boyd's point, if usual and customary means whatever the insurers say it is, then you're reading agreed to out of the language of the contract, because they would never have any incentive to reach an agreement at a higher rate with out-of-network providers if usual and customary meant whatever they said it meant. I want to return to a couple points. See, Chapter 541, your question about Chapter 541 damages at the very beginning, at the very end of my presentation, I think 541-151 sets forth a right to actual damages plainly under the statute.
I wasn't on social media. My laptop died, but I did look up 541 using my phone while your friend on the other side was arguing, so
very good.
I cleared that up.
Well, with that, Your Honors, unless you all have any additional questions, I appreciate the opportunity to appear before you.
Any other questions? Thank you, Mr. Trachtenberg. The case is submitted. That concludes the arguments, and the case is set for this morning, and the marshal will adjourn.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.